USCIS can now deny an immigration case without first issuing a warning. We have a major USCIS policy update to cover in today's video, so make sure to stick around. So let's jump right in. For years, the way the immigration system worked was that if you submitted an application or a petition to USCIS and USCIS needed clarification on a particular aspect of the case or had questions or wanted to see additional evidence on a particular aspect or multiple aspects of a case, they would typically issue something called an RFE, a request for additional evidence. And as the name suggests, a request for additional evidence was a document submitted by USCIS to the person filing the request for the immigration benefit that would highlight different aspects of the case that USCIS wanted to see additional information about or wanted clarification on or wanted to see additional evidence, whatever the case may be. Now, due to this recent policy update, USCIS, as I mentioned, has given officers in certain cases the discretion to deny a case without first issuing a request for evidence. So there's multiple important points with this recent policy update. I want to cover them to some extent, so let's jump right in. This took place on August 5th. On August 5th, USCIS issued a policy alert updating its policy manual, and there's essentially 4 big updates with this policy alert, and I want to go through each of them. The first one, and it's the one that I just highlighted, is denials without warning. Officers can now deny a case without first issuing a request for evidence or a notice of intent to deny. A notice of intent to deny is more severe than a request for evidence because it's basically USCIS letting the person know that they're intending to deny this application or this petition because of the following deficiencies. It still gives the filer of those immigration benefits the opportunity to correct those deficiencies, so there's still an opportunity to cure, but it's a more severe action from the standpoint that USCIS is essentially expressing a greater degree of skepticism as to whether this case can ultimately be approved. So just to give you a sense of what those two terms are, but again, officers can now deny a case without first issuing a request for evidence or a notice of intent to deny in 3 situations. The first situation is if the required initial evidence is missing from your filing. If you file your case in a fashion that's somewhat deficient with respect to the required initial evidence, USCIS officers can now deny the case without first issuing an RFE. Second, if the evidence you submitted doesn't establish that you're eligible, or in the third situation, if your case has no legal basis for approval that more evidence could fix. An important point that I want to highlight here. So we covered 3 bases by which a USCIS adjudicator could deny a case without first issuing an RFE. Important to note is that USCIS officers can still issue an RFE. This policy update does not preclude immigration officers from issuing an RFE, but it gives the immigration officers the discretion to deny a case without first issuing an RFE if one of these factors is present in one of these enumerated situations. So that's the first big update with this USCIS policy alert. The second update is regarding shorter deadlines to respond to RFEs. Now, for years, USCIS officers, when they issued a request for evidence, they would offer the maximum allowable time to respond to the RFE, which was 12 weeks. Under the new policy, 12 weeks is only the maximum. Officers can set the deadline on a case-by-case basis, and in some cases, they can give much less than 12 weeks. So you can imagine, oftentimes when USCIS issues a request for additional evidence, they are questioning multiple aspects of the case. And oftentimes it takes a lot of time to compile the required documentation, to prepare a response sufficiently, and to respond. So this component of immigration officers, USCIS officers, now potentially issuing less time to respond to one of these requests is a big deal. The third change that I want to highlight in today's video is that the international mail grace period is gone. USCIS used to add 14 extra days for notices mailed abroad. That is now eliminated. Now everyone gets the same 3 additional mailing days, whether the notice is going somewhere in the United States or somewhere abroad. And now this is a 4th update that is so minimally presented in the policy alert that it's very easy and very likely that many people may have missed this. And the 4th update, and again, it's a detail that's buried in this policy alert. It says, if you respond to a request for evidence with only part of what USCIS asked for, USCIS can treat that response as if you're asking them to decide the case on what's already in the record. Now that we covered kind of a high-level overview on what this policy alert is doing, I want to talk about something else that's very important and why this is so urgent, so important to be aware of. This policy update, again, it was put into place on August 5th, 2026. Not only does this policy apply to all cases filed from August 5th and onward, which it does, it also applies to cases that were filed before August 5th and are currently pending with USCIS. So that means that even if this policy was not in place, which may be the case and is the case for many, many people, but they filed their cases and those cases are pending, this policy update applies to those cases as well, in addition to all cases that have been filed from August 5th moving forward. So that's very important to be aware of as well. Now, another important point that I want to cover is why USCIS put in place this update. And it cites to a couple of different reasons. For one, it's citing to the fact that it wants to essentially reduce the volume of these kind of placeholder filings where someone will just submit a bare bones filing with just minimal documentation with the intention of curing the defects or the minimal nature of the evidence, essentially get it filed and then correct it and improve it later on. They want to essentially reduce this practice. Similarly, they identify situations where people are filing cases that don't really have a chance of approval, but they're filing these cases to get certain ancillary immigration benefits that come along with those filings while the application is pending, like employment authorization. USCIS wants to essentially reduce these practices, and to the extent that they can eliminate these practices, they want to do so. And this policy is one way to achieve that end, according to USCIS, or attempt to achieve that end. So now we covered a high-level overview of the policy. We covered USCIS's stated reason for implementing this policy. Now I want to share with you some insights into what this means for you. So when they're filing immigration cases, some people have the approach, or maybe not even a real conscious decision, but people may or may not intentionally file a case with minimal documentation and feel that they can cure it later on. Also, sometimes people file a case and they'll keep some evidence in reserves with the intention that if USCIS submits a request for evidence, they'll have some additional ammunition, basically, to submit to further bolster the case later on if USCIS issues an RFE. Well, with this new policy, it seems to be that it's very important to put your best foot forward on the initial filing, because there may not be a second chance to cure whatever deficiencies that USCIS may perceive within your case. So again, it may be the best approach to file your strongest case on the initial filing. Again, you want to consult with your immigration attorney. This is just general information, not legal advice to anybody's particular case, but it seems now the margin of error on a case is very slim. So people that may just want to push something through and then correct it down the line, or people that might have the mentality that they want to intentionally hold on to some evidence in the event that they get a request for evidence so that they can further bolster their case. It seems that with this policy, that approach may not be the correct approach because there may not be a second chance. Again, with this policy, people that are considering immigration petitions, it seems to be more important to put your best foot forward on the initial filing rather than waiting for a second shot, because that second shot may not come. So there you have it. Important USCIS policy alert published on August 5th, affecting cases that are currently pending that were even filed before August 5th, affecting future cases. Now, it's going to be interesting to see to what extent USCIS officers and adjudicators exercise this discretion and actually deny cases without first issuing an RFE. Because again, as I mentioned, this is not a requirement for USCIS officers to deny cases outright. They still have the discretion to issue an RFE or a notice of intent to deny if they see fit. But they do now have that discretion to deny a case outright under those circumstances that we highlighted. So hope you got some good value from this video. Hope you learned a lot. If you know anybody that can benefit from this information, please feel free to share this video with them. As always, thank you so much for tuning into this video, and I'll see you on the next one.